Your Honour, if it pleases the court, my name is Wetzler, initial JM. My client's name is Marshall Ike, and he has faced unfair treatment from representatives of the Queensland Police Service, resulting in what can only be called unjust. Now the facts are as follows. Mr. Ike was picked up by police near the scene of the crime by two plainclothes police officers who gained the only bit of evidence relevant to the charges in question. This evidence must be excluded, as it was gained by officers acting improperly and arguably illegally, as per Bunnings and Cross. Subsequently, this is a Criminal Code Section 509AA argument, making the evidence inadmissible. Section 130 of the Evidence Act allows for this. Mr. Ike is 14 years old, making him a minor. Section 421 of the Police Powers and Responsibilities Act clearly states that he has a right to a parent or a guardian being present. Nothing was done to inform anyone of this. He was not even informed of his right to silence as per Section 431 of the same Act, which has been found to be very prejudicial, as seen in the case of Lee. Mr. Ike is also Indigenous. He's a Torres Strait Islander. And as seen in the Supreme Court's Equal Treatment Bench book, on page 90, there is this cultural and philosophical issue called gratuitous concurrence. This is the idea that someone in a position of vulnerability, such as my client, would be likely to agree with propositions put to him, even if he does not actually agree or even understand the questions put forth. This has been found to be a very common trend in Indigenous people, as a means of conveying cooperation and avoiding conflict. Now, in my client's mind, nodding and saying yes isn't an admission of guilt. It's an attempt to show cooperation, in hope that things will work out well. Had he been informed of his right to silence, it would be unlikely that this would have happened. Even if that were not the case, had a parent or a guardian been present, he would not be in such a vulnerable position. And even if both of these factors had no impact on my client, this still would not have happened had he been treated properly, and the police had not breached their duties under the Police Powers and Responsibilities Act. Due to the cultural background of my client, Section 420 of the Police Powers and Responsibilities Act makes him a relevant person, of whom his which is entitled to legal aid, who must be notified upon his arrest. He was denied access to representation or even anyone with a legal background to speak to. Had legal aid been informed as per the law, gratuitous concurrence would not have occurred. This has led to a massive disadvantage to my client and is a breach of Section 420 of the Police Powers and Responsibilities Act. This means the evidence was gained improperly, and I ask you to exercise the lead discretion, which has allowed evidence to be thrown out due to gratuitous concurrence. Now, yes, there was a social worker. However, she did not inform my client of his legal rights. As a matter of fact, she did quite the opposite and insisted he answer all the questions. This suggests either a bias towards the prosecution by this social worker, or simply no understanding of the law whatsoever. This cannot be suggested to be of any support to my client, and if anything, it had a negative impact on the likelihood of him seeing justice. On top of this, the support person was not provided till after the original questioning, and at this point, there was already a prejudice in play. This person was neither a guardian nor a person from legal aid, and cannot be used as a replacement for either. Now, there is well-established common law by Hassler that it is hard to dismiss evidence that is not slight or insubstantial. And as this is, the key and only piece of evidence for the prosecution, I won't argue that. However, Your Honour, I ask you to exercise what is known as the Christie discretion. This is one of fairness. Now, the evidence may be significant, but the prejudicial effect of the evidence is substantial enough to warrant the exercise of this discretion. It is a balancing act, I understand, and in the olden days, the court would only throw out evidence if it was slight. However, I would direct your attention to the case of the Crown and Brown. The court has accepted that it's no longer a matter of how significant the evidence is, necessarily, but it's a question of whether or not this significance is outweighed by the prejudicial effect of the evidence. This is where a jury would give this evidence more weight than it deserves and would likely be inflamed by it. Now, most reasonable people would be inflamed upon hearing the admission of robbing so many places, and most wouldn't even want to consider my client's innocence. I mean, empathetically speaking, The jury see a young man, they see an Indigenous background, they see a guilty plea of robbing so many places. They're not going to consider whether or not the evidence was obtained correctly. It is clear that this significance is clearly outweighed by the prejudicial effect of the evidence. Not one person on this jury would consider that a 14-year-old boy, thrown in the back of a paddy wagon, who is then questioned with no representation or information on their legal rights, would be incredibly intimidated. Now, if you combine this intimidation with this philosophical and cultural idea of gratuitous concurrence, what young person wouldn't say that they thought they could appease their questioner and that they wanted to defuse the situation? He was vulnerable, and this is why minors are entitled to support. They need support from the law and from their parents. And any evidence obtained without these things is outrageously prejudicial. Therefore, the significance of this evidence ought to be set aside in the name of justice. My client is not guilty. That is all, Your Honour.